Hello friends, welcome back. Myself Pushpender Singh, and today we are going to see the polity questions, right, and their solutions for the UPSC Civil Services examination, which is conducted by the UPSC. So we are going to see only few questions. Myself Pushpender Singh, and I have done the BTech from IIT Madras, MTech also from IIT Madras, and I have appeared in the civil services examination thrice, right? And I've appeared in the mains examination thrice in 2015, 2016, and 2018 with the geography option. I have also appeared in the Indian Forest Services mains examination in 2018, right? So let's discuss with the polity questions, right, and their solutions. Okay, so first question here we are taking from the Civil Services Prelims 2021 this year examination. So here the question says that the legislation which confers on the executive and the administrative authority an unguided and uncontrolled discretionary power in the matter of an application of a law violates one of the following articles of the Constitution of India. So this question clearly tells us or clearly asks us, right, that whatever the legislation which confers that type of an discretionary power, right, violates which of these following articles. So first of all, before we proceed to that question or to that solution to that question, first let us understand what is the discretionary power is all about. Because without understanding the discretionary power, you cannot simply answer this question. So the discretionary powers, which are first of all, they are exercised by the administrative authorities, okay, and they are also exercised by the legal authorities. Okay, now they are basically permissive and they are not binding. These powers are basically granted to those officials, right, by the statute or by the levy or by the delegation. So either with the help of the statute or with the help of a delegation, right? With the help of a delegation of these powers. So discretionary powers do not impose an obligation on the decision maker to exercise them. There is no such obligation to exercise them, right? Or to exercise them in a particular manner. So these administrative authorities or the legal authorities, they must exercise this power or the discretionary power in accordance to the legal requirement, right? So they must be used the reasonably, impartially, and avoiding operation or unnecessarily injury on the public. Right. This is what the guiding principles of the discretionary power is all about. Now, one thing that will be coming to your mind is that why these administrative agencies are giving these broad powers or broad discretion to exercise these powers. So generally, the statutes expressly confers these right to exercise this discretionary power to those agencies to utilize their expertise in their field. Okay, so now let us come to the question, right? The question says that, right, that the legislation which confers right on either executive or administrative authority an unguided and uncontrolled discretionary power would violate which of these following articles. So first let us start with article 14. Article 14. So what is Article 14? The Article 14, which basically says about the equality before the law, right? Equality before the law. Now, this article says that the state shall not deny to any person, right, the equality before the law or equal protection of the law, right? It also says that about the equal protection of law. So it says that the state shall not deny, right, any person, right, the equality before the law or equal protection of the law. So it says that state shall not deny. So you must remember that article, right, to any person, to any person, right, equality before the law or equal protection of law. So this is the clue here, to any person, to any person. It is not saying about either the citizens or to someone. So it says that to any person it is basically applicable, right? But that person would be there, right, or that law will be applicable within the territory of India. So if the officer is given the uncontrolled discretionary power, what will happen, you can think of, it will definitely violate article 14, because it says that should not deny to any person equality before the law or equal protection of the law. But if you give them uncontrolled and unguided powers, what will happen? There will be a temptation, or there will be a chances, or there will be a possibility that a particular officer might violate the Article 14. So Article 14 could be the possible answer. Article 14 could be the possible answer. So we must say that we must just say yes, it could be the answer. It could be the answer because we have not yet seen the another options. So second question is Article 80, Article 28. What is the Article 28? The Article 28, which is basically belongs to the freedom of religion. It belongs to the freedom of the religion. The freedom of the religion that comes from Article 25 to Article 28. Again, this is again your fundamental right. So this Article 28 specifically says about the freedom from attending the religious instructions. The religious instructions. Now, this again is not fitting over there. It's not fitting over there, right? Because it's not applicable over there. So this cannot be answer. This cannot be an answer. Then Article 32. Article 32, which is basically said about, the remedies or the constitutional remedies. So it's a remedies for the enforcement of the fundamental rights. Enforcement of the fundamental rights. So here Article 32 basically deals with, right, or it gives the power to the Supreme Court, right, you know the power to guarantor as well as the defender of the fundamental rights of the citizens. Now the Indian citizens have the right to move directly to the Supreme Court, right, for the enforcement of any violated fundamental rights. So here the Supreme Court cannot deny this right, which is a fundamental right which is given to the citizens by the Constitution itself. Again, you can see that it could be also an answer, but here the point is that it could be the answer. But if you compare Article 14 and Article 32, Article 14 would be looking more appropriate answer, right? Right. Then Article 44. Article 44 again it is said it is a part of the DPSP. First of all, Directive Principles of the State Policy, which is in Part 4 of the Constitution. Now here it says that about the Uniform Civil Code, the UCC. Again, it is not fitting in this answer. Again, it is not fitting right over in this question. So what could be the probable answer of this question would be answer A, or option A would be the probable answer. So if the legislation which confers on executive or administrative authority any unguided or uncontrolled discretionary power, right, definitely it will violate, right, the Article 14, right, with the heart. Okay, so this is what Article 14 would tell us, right, would tell us. Okay, now we shall move to the second question of the today's topic. Okay, that is also I have taken from the polity. Okay, so it says that what is the position of the right to property in India? Again, this has taken from this year's civil services prelims question paper, which has been asked by the UPSC, right? So here it says that what is the position of right to property in India? So first of all, this right to property was our fundamental right. It was our fundamental right under Article 19, right? Clause 1, Clause F, subclause F, right? As well as Article 31. These two articles were related to your fundamental rights. These were related to your fundamental rights. But now these rights or these fundamental rights have now been repealed. So I will certainly give you an answer for this question, but before that, we shall understand the background behind this the repealing of this right to property, right? Then only you will be understanding, or you will be understood, right, what is the position of right to property in India. So first of all, Article 90, which is basically related to the rights or fundamental rights of the citizen. So it has the Article 19, it has various rights like the right to freedom of speech and expression, right to assemble peacefully without arms, right to form an associations, the unions, right, right to move freely throughout the territory of India, right to reside and settle, right, in any part of the territory of India. And again, Article 19(1)(f). This Article 19(1)(f), which says that it is basically guaranteed, you know, the Indian citizens, you know, right to acquire, hold, and dispose a property, right? This was Article 19 clause 1 subclause F. It says that it guaranteed Indian citizens the right to acquire, right to hold, and the right to dispose a property, right? Article 31, which is basically related to the compulsory acquisition of the property, compulsory acquisition of the property, right? It is basically related to that. Now, what was happens in 1951, or what was happened in the post independence, right? What happens is the Indian government basically resorted to the land reforms, related to the land reforms. Now, this Article 19(1)(f) and Article 31, this comes in the way of the land reforms. The people went to the court, right, for protection of their property, because the government of India started acquiring the property, but this was a fundamental right. And now a lot of litigations were there in the Supreme Court and the High Courts, right? So the state or the government of India was unable to take the steps on the land reforms. And ultimately in 1978, the Janata Party government, right, what happens? The Janata Party government brought 44th Constitutional Amendment Act. Okay, this Constitutional Amendment Act was brought, right, by Janata Party government in 1978, and this basically repealed both Article 19(1)(f) and Article 31. So repealed, both articles repealed, right? And in place of that, a new Article 300A was basically inserted. This is the new article which was inserted, in the constitution, right? Now this fundamental right consequently become, right, or this fundamental right which was previously, right, the right to acquire, right to hold, and right to dispose the property, now it has become a mere, a constitutional right or the legal right, right? And it could not be challenged in the courts on the basis of a constitutional law. So Article 31, which says that no person could be deprived of the property without the due process of the law, uh, right? Or the state shall take a possession or acquire any property for the public purpose. Now it is possible, after repealing this Article 31, now it is possible for the government of India to take over this private property for the public use. So this was the purpose. Now they could use this private property for the public use. So originally, this right to property was one among the seven fundamental rights under Article 19. This was one among the seven fundamental rights. But by 44th Constitutional Amendment Act 1978, this Article 19(1)(f) and along with Article 31, which was completely repealed. Now, this was repealed by 44th Constitutional Amendment Act, and it has made, right, just a legal right, right, under Article 300A in part 12 of the Constitution. In part 12 of the Constitution, the right to property, or it has just made a separate article, right? It provide that, what is the Article 300A? Is provide that no person shall be deprived of his property except by the authority of the law. Except by the authority of the law. So this says that no person shall be deprived, right, of his property except by authority of the law. So it says that no person, it says no person. So what does that mean, the no person, right? Again, it has not become a part of the basic structure now after introducing Article 300A. So it says that no person, read that line, no person shall be deprived. So this is says that no person. When it says no person, that means it is it does not simply involve basically citizens, but it will involve, right, to any person, or it will basically extended to any person, since the article says that no person shall be deprived of his personal property except by the authority of law, right? So the statement clearly says that the legal rights available to, right, to any person, to any person. So definitely, this legal rights available to the citizen, this is the first option. To the citizen, it says that no person. So no person is much bigger than the citizen. See, the person could be a citizen or non-citizen here, right? So here it is applicable beyond the citizens also, right? So definitely this could not be a fitted answer. This would be a wrong answer. So legal rights available to any person, to available to any person, right? This is the most fitted answer. It says that fundamental rights available to the citizens. No, it is not true, because it is no longer a fundamental right. It is no longer a fundamental right. It is neither a fundamental nor a legal right. No, this is also wrong, because yes, it is true that it is neither a fundamental right, but yes, it is a legal right. It is a legal right. So definitely the D answer also wrong. The D answer also wrong. So what is the most appropriate and the correct answer? That is answer B. That is answer B. So this would be the most appropriate and the correct answer, right, for the position of the right to property. So certainly we can say that now it has become, right, your constitutional and the legal right, right? It was previously one among the seven, right, the fundamental rights under Article 19, but it has been repealed, right, by 44th Constitutional Amendment Act, and both Article 19(1)(f) and Article 31 both have been repealed. Now it has been made a just legal right under Article 300A in the Part 12 of the Constitution, which clearly says that no person shall be deprived of his private property except by the authority of the law, except by the authority of law. All right. So I hope both of these questions would have clear to you, right? If you have any doubt, you can always ask to me, right? So we shall wind up today's session, and we will discuss the remaining portion in the next class. Thank you very much for attending this class. Thank you.